What are the consequences of refusing a breathalyzer test in NJ? If you're ever pulled over in New Jersey under suspicion of drunk driving, the moment can be nerve-wracking. One key decision you may face is whether or not to submit to a breathalyzer test. While refusing might seem like a strategic move, it comes with serious legal consequences that every driver in New Jersey should understand. Legal framework in New Jersey enforces strict laws against driving under the influence. Under its implied consent law, by simply driving on the state's roads, you automatically agree to submit to a breathalyzer test if suspected of DWI. Refusing isn't a criminal offense, but it's still a violation that brings significant penalties. Even without a breath test, police can arrest a driver based on observed behavior, and refusal can still be used as evidence in court. If law enforcement had no probable cause or didn't properly inform you of the penalties, an attorney might be able to challenge the refusal charge. What are the consequences of refusing a breathalyzer test in NJ? Refusing a breathalyzer test can lead to a range of penalties depending on prior offenses. For a first-time refusal, the driver faces a fine of $300 to $500, a license suspension between 7 to 12 months, and mandatory installation of an ignition interlock device. The device must stay installed during the suspension and for an additional 6 to 12 months after license reinstatement. A second-time refusal increases penalties to a $500 to $1,000 fine, a license revocation of up to 2 years, and an ignition interlock requirement for up to 3 more years. Third-time offenders risk an 8-year license revocation and a $1,000 fine, plus the ignition device mandate for up to 4 years. In addition, New Jersey imposes a $1,000 annual surcharge for 3 years, and insurance rates often increase significantly. It's also important to know that the refusal remains on your driving record permanently, unlike criminal records that may be eligible for expungement. How does the refusal process work? When pulled over, police are required to read a standard statement to inform the driver of the consequences of refusal. Saying no isn't the only way to be charged. Remaining silent, giving short or insufficient breath samples, or delaying the test can also count as refusals. The courts expect a clear and unconditional agreement to take the test. If you respond with hesitation or conditional language, like, if I, or, can you tell me, it can be treated as a refusal. New Jersey primarily uses the Alcotest 7110 MKIII-C, and results can only be used if the device is properly maintained and operated. A lawyer may challenge refusal charges based on improper calibration or the officer's lack of training. Medical conditions like asthma can also play a role, as they might prevent a person from providing an adequate sample. If you're facing breathalyzer refusal charges, understanding the stakes and knowing your rights is crucial. A law firm experienced in DUI cases can help determine if your traffic stop followed legal procedures and assess whether your refusal charge can be reduced or dismissed. A DUI attorney can also represent you in court, work on alternative sentencing, and negotiate with the prosecution on your behalf. Protecting your license, finances, and future starts with experienced legal guidance. Reach out to the Kugel Law Firm to schedule your free initial strategy session. Call 973-854-0098 or visit us at 1 Gateway Center No. 2600, Newark, New Jersey, 07102, United States.